address the needs and concerns of all Nigerians. The justice sector has made remarkable progress in recent years, driven by dedication and hard work of the departments and units of the ministry, partners and stakeholders. Permit me to highlight some of these achievements. 1. Development and adoption of the National Policy on Justice 2024-2028. The National Policy on Justice 2024-2028 was developed in collaboration with stakeholders. The next step. Distinguished ladies and gentlemen, the next steps are as follows. 1. Gazetting and signing off the national minimum standards by the Attorney General of the Federation. 2. Organize sensation workshop on national minimum standards. 3. Printing in 3 major languages and Pidgin English. Number 4 now, restorative justice framework. Distinguished directors, distinguished ladies and gentlemen, review and validation of restorative justice document for the FCT, that is the Bill, Policy, Practice Direction and Training Manuals 2025 to 2027, June 2024. This activity aims to review and validate the legal framework for implementing restorative justice, otherwise known as RJ in the FCT. A restorative justice is an alternative approach to traditional justice system, which focuses on punishment of the offenders rather than reintegration, considering victims, offenders, and the community, and bearing in mind that the purpose of punishment is not to destroy but to build. Capacity building workshops and sensitization sessions for stakeholders on restorative justice implementation in the Federal Capital Territory, September 2024. These aims to sensitize stakeholders about the restorative justice legal frameworks and equip them with necessary skills in the implementation of RJ in FCT. On this note, I want to discuss the next step under this. It is the setting up of Restorative Justice Center in Federal Ministry of Justice and ensure that the multi-door courthouse center is well equipped to meet the need of all clients and stakeholders. Capacity building for facilitators on implementation of RG to commence second quarter 2025. Then the next major issue I want to deal with is plea bargaining. Signing off and unveiling of plea bargaining guidelines for federal prosecutors, December 2023. This provides a comprehensive framework to guide plea bargaining practices for federal prosecutors and standardization, fairness, and transparency of the process of plea bargaining. Need assessments on plea bargaining process conducted for prosecutors, the judiciary, and the Nigerian Bar Association, NBA, July 2024. The aim of this program was to identify gaps and challenges in the implementation of plea bargaining as judiciary, prosecutors, and NBA. Capacity building workshops and stakeholder sensitization for justice actors on plea bargaining, that was in October 2024. The fulcrum of this program was to sensitize the justice sector actors on plea bargaining. Then I deal with the next step. In the 5-month capacity building commencing from November 2024 to May 2025. So, 6, I discussed the non-custodial sentencing initiatives. Capacity building workshops on non-custodial measures using the Federal Capital Territory, High Courts, custodial and non-custodial sentencing Practice Direction 2020, produced by the Federal Ministry of Justice in collaboration with the FCT Judiciary to enable courts in the Federal Capital Territory that exercise criminal jurisdictions to award non-custodial sentences in line with the provisions of the Administration of Criminal Justice Act and Nigerian Correctional Service Act 2029. This is aimed at discongesting the custodian sentence, facilitation of speedy dispensation of justice. The ministry built and furnished courts in Kirikiri prison in Lagos and also installed a virtual court system to fast-track the trial and discongest the custodian sentence. I will be handing over the key to 2 of the courtrooms to the Honorable Chief Judge of Federal Capital Territory and 1 courtroom to the CJ of Lagos State in Lagos. Justice Information Management System. This initiative aims at addressing the inefficiencies in Nigeria's criminal justice system through technological advancement. The purpose is to develop a justice information management system that will incorporate case management and biometric technology to enhance coordination and transparency and efficiency among justice sector institutions. Day 2, strategy session with ICT officers of the MDAs on the development of JIM 16 to 17 December 2024. Excuse me. These aims for MDAs to present status of database systems of their institutions, summary of their existing databases, and operability and drafting of a comprehensive statistical data framework. Number 9, child justice reform. Review and validation of prosecution and legal aid guidelines for children in contact with the law, March 2024. Provided a legal framework for handling cases of children in contact with the law. Capacity building workshops on improving child justice measures across MDAs, April 2024. Furthermore, there is a national workshop on child justice administration. The focus of this meeting was to build the capacity of stakeholders on best practices in child justice administration. What then is the next step in this regard? The next steps are: 1, signing off of the guidelines by the Attorney General of the Federation. 2, distribution of the guidelines to stakeholders. 3, conduct sensitization workshop for stakeholders on the availability of these legal instruments. Support for bolster institutions is the next issue I want to deal with. Review the Bolstered Remand Centers Act 2004 and now the practices and abuse of office. 9. Integrate technology innovative solutions to modernize the justice system, enhancing efficiency and transparency. 10. Mainstream the role of justice system in enhancing national security, supporting fair, credible, and violence-free elections, and facilitating economic growth. 11. Encourage compliance with Nigeria's treaty obligations and promote international cooperation. Towards the realization of the above objectives, the policy identified 20 thematic areas of focus as provided here. I named them, these areas. The first one is 9 of the items focus on strengthening the process of delivering justice and protecting the rights of citizens. For want of time, I will skip this, but let me just, I mentioned them, but not in details. When we finish, we'll give you a copy of this speech, which contains details of all that have been done. Three others seek to strengthen the justice institutions and promote effective collaboration between federal and subnationals. Number 4, is the three teams extend the support of the justice system to other spheres of national development. 5, which is the final one, two themes that deal with the role of justice system in ensuring that Nigeria continues to play an influential and responsible role in the Committee of Nations. The policy on justice was validated and adopted by all stakeholders at the National Summit on Justice held on the 3rd of April 2024. The National Policy on Arbitration and Alternative Dispute Resolution 2024, in an effort to enhance the practice of arbitration in Nigeria, promote Nigeria as an arbitration hub in Africa, create an enabling environment for foreign direct investment in Nigeria, thereby promoting the development of our national economy, the ministry. The ministry, in collaboration with stakeholders, developed the National Policy on Arbitration and Alternative Dispute Resolution 2024. The policy seeks to stimulate economic growth by attracting foreign investment, strengthening professional capacities, developing critical arbitration infrastructure, and establishing clear, structured guidelines for government agencies in negotiating and participating in arbitral proceedings. The objective of the policy is to transform Nigeria into a competitive, internationally recognized arbitration hub with transparent, efficient, and globally compatible dispute resolution mechanisms. The policy has also been approved by the Federal Executive Council for national implementation in July 2024. Implementation of Administration of Criminal Justice Act 2015. The Administration of Criminal Justice Act 2015 seeks to reform the administration of criminal justice through speedy dispensation of justice, protection of human rights, accountability, and oversight between and amongst criminal justice institutions. Since its enactment, the Ministry has been leading efforts to ensure its effective implementation to ensure citizens' access to justice and protection of their rights. The Ministry, through various reforms, supported states to replicate the Act through the adoption of their own Administration of Criminal Justice Law, otherwise known as ACJL. Today, I'm happy to inform you that 36 states of the Federation, all the 36 states of the Federation, now have their ACJL, which to a very large extent replicates and further strengthen the provisions of ACJA for effective implementation at the state level. Capacity building. Capacity building is the next item I want to consider. And I'm saying that in furtherance of this, the Ministry, through the Federal Justice Sector Reform Coordinating Committee, has been supporting states to implement the state ACJLs through capacity building of the criminal justice administration stakeholders in the states. Between December 2023 and 2024, capacity building has been undertaken in 12 states, particularly as it relates to the implementation of sections 29, 33, and 34 of Administration of Criminal Justice Law 2015, Police Act 2020, and ACJL of the various states. Section 29 of ACJA mandates the Inspector General of Police and heads of authorized agencies to submit quarterly reports to the Attorney General of the Federation and respective Attorneys General of respective states, detailing all arrests made with or without warrant in respect of federal offenses. The reports must comprehensively document suspect details, including alleged offenses, arrest circumstances, personal particulars, physical description, photographs, fingerprints, and distinguishing features. The Act further requires maintaining a register of arrests at each police station and authorize the Attorney General of the Federation and various Attorney General of states to establish both electronic and manual database of arrest records at the federal and state levels. Section 33 of the Act mandates the officer in charge of police stations and law enforcement agencies to, on the last working day of the month, submit to the chief magistrate in charge of the magisterial district where the police station is located, a report detailing all arrests made with or without warrant, including specific personal and arrest-related information such as alleged offenses, circumstances of arrest, suspects' details, and identification particulars of the suspect. The Attorney General is obliged to make these reports available upon request to human rights organizations, and in cases where no report is submitted, the magistrate must escalate the matter to the Chief Judge and the Attorney General for appropriate action. Section 34 of the Act mandates the magistrate to conduct monthly inspections of police stations and detention facilities within their territorial jurisdiction, with the provision that in the absence of a chief magistrate, any magistrate designated by the chief judge can perform such duty. In the course of the visit, the magistrate is expected to 1. Inspect the police detention register, 2. Inspect the cells, 3. Interview the suspects to know when they were arrested, the offenses for which they were arrested, and whether they are humanely treated while they were in detention. Furthermore, grant bail in deserving situations where the magistrate has jurisdiction. This capacity building has been conducted in the following states. The states are put there, they are 12 in number. Total stakeholders, 1,623. I am happy to report that in the above states, these provisions are now being effectively implemented. The ministry will continue to expand the coverage of the capacity building on the other states to ensure that these far-reaching provisions and reforms in the administration of criminal justice are implemented nationwide. Then the ACJA Forum on the effective implementation of ACJA and ACJL, 25th to 2027 October 2023. These programs aimed to review the implementation of ACJA 2015 and develop draft national minimum standards for uniformity across states and to aid the effective implementation of ACJA 2015, 9 years after its passage. Review the development of human rights standards, NMS, for ACJA and ACJL implementation, July to September 2024. Review and develop the national minimum standard, aids to create a benchmark for the implementation of ACJA and also to set a baseline that ensures monitoring and evaluation. Furthermore, validation of the national minimum standards on implementation of ACJA and inauguration of the National Working Group on ACJA and ACJL implementation. The inauguration of the technical